Today we saw that one of the participants participated in a West. I've received large number of messages to the effect that there should be certain hygiene conditions maintained while participating in the uh, this platform. If he actually feels that he's not dressed up in the right sense, he can always stop the video, hear to them, because once you have keynote speakers just like Mr. Banerjee, and tomorrow we are having Madhvi Devan, day after tomorrow we are having Dushyant Dave, Mr. Justice A.K. Sikri. They are all treat to be heard. No doubt, hearing and seeing on the video gives a different treat to the eyes and the ears. But if one has a personal difficulty, he can always stop the video. And over to Mr. Banerjee. And I'm quite sure that everybody, when the meeting is over, he will feel that he has gained something for all times to come. Thank you, Mr. Banerjee.
Thank you, Vikasji. I think, Vikasji, your introduction to me has been excessively kind. I don't think I deserve that amount of compliments, but be that as it may, we won't go into that at the present moment. What I'll do is I think I'll address the topic which has been given to me about contempt and its challenges. But most importantly, what I'll try to do is I'll address it in a short period of time, because I do not intend to go into the entire questions of what is contempt, what are the laws of contempt, and except to touch it in passing. My proposition to you and proposition to anyone who's listening to me, I assume that you know we all are lawyers, we largely are professionals, most of us have a great experience, some even much more experience than I am. So what I would like to sort of highlight is there are increasing challenges which the contempt jurisdiction is facing, increasing challenges as lawyers who are appearing before contempt jurisdiction, before different courts are facing. And in the end, I would like to sort of conclude with what is my suggestion as what do I think that the court should do in handling this contempt jurisdiction. The first question is, when we are starting is, why do we need the power of contempt? I think that's a very crucial question. There are two places or two institutions which use this contempt power frequently, or they have that power of contempt, which we are used to, which we hear quite frequently. One is the parliament and the other is the judiciary. The reason, as we all know, is the use and power of this contempt jurisdiction is to ensure two things. Number one, the majesty of the institution is kept, is protected, and the institution is not brought into disrepute. One of the entire facets of it, this is required because we live in a democracy which has freedom of speech and expression. People tend to express themselves, and not everybody is as restrained as they should be. Not everybody is as respectful as they should be. So people express their views, some very articulately, some very vociferously, some very angrily. As a result, there are, we function in a democracy where the three pillars of government are extremely important, and they are the key to the democratic state that we have today. So if the parliament is brought into disrepute, if the judiciary is brought into disrepute, then that affects broader governance. So historically, I think this is not new. Historically, I can go into a long history of how the British Parliament used to exercise its power of contempt, though it's become lesser and lesser, much become infrequent now. And the judiciary also, because the judiciary has, in Britain, used to use at one point of time contempt very, very frequently. But over a period of time, there has been this tendency of not using it as frequently as it used to. Now, another reason for especially both these institutions use power of contempt, and especially the judiciary, is to ensure that people follow its decisions. Because unlike the executive, cannot enforce the decisions by itself. And all of us know the executive has the wherewithal and the means to implement those decisions, to enforce those decisions. So if there is an order passed by the executive and people don't follow it, then the executive can go and physically ensure that those things are handled. That is not present with the judiciary, because the judiciary, being as an institution, decides. So the only way it can ensure that its orders are complied with, and so that's its job, it decides on disputes between people, and it sort of ensures that the dispute, the resolution which it has come out with can be implemented, is through the power of contempt. Contempt basically is of, there are provisions in the Constitution which are specific provisions, and all of us know that freedom of speech and expression has a specific exception for contempt, saying that, like defamation, contempt is an exception, saying that you may have the freedom of speech and expression as a fundamental right, but you cannot commit contempt. Now, we know that there are provisions in the Constitution which explicitly give the courts that power. The high courts, I think, high courts and Supreme Courts have that power. The Supreme Court has in Article 129, the high courts in 215. In context of parliament and assemblies, they have privileges and immunities, and contempt is a part of the privilege of the parliament. This is an old historical remnant. In India, it has also been used. It's been used a number of times. It's the same thing, that in case you sort of violate or do something which brings the parliament into disrepute, then the parliament has the power and the privilege to act against you. Article 105, Article 194 sets out the broader powers and immunities of the parliament. And one of the important powers that the parliament has is the power to punish people for contempt of itself. Now, this is an old heritage coming to us from the British Constitution, from British constitutional law, from British Parliament. But be that as it may, I don't think we're going to concentrate too much on parliamentary powers of contempt, though it's also a greatly debated issue. It's a greatly debated issue in constitutional law. It is also a greatly debated issue in Indian law as well, as to what are the powers, what extent a person can be punished for contempt of the parliament, etc., etc. But that's not the scope of today's discussion. Our discussion largely is going to be on judicial powers of contempt, and how do we lawyers handle that sort of power? How do we face it? What are the challenges we face? Now let's come into the question of judicial contempt. Now, again, I know that I'm just taking things to you who are quite aware of all these issues. People, lawyers like us, have deep experience of all these issues. So I'm not going to, explain to you in detail. But we are broadly, and I'll say this because that's the context of what I'm next going to submit. We are aware there are two types of contempt. One is a civil contempt. A civil contempt, as we all know, is for, if somebody doesn't comply with an order of court. And we all use civil contempt very, very frequently because it is through civil contempt which we get orders complied with. Now, all of us know that we can either get an order complied with through execution of the order, or we can get it complied with contempt. And we know, again, from experience, that it is contempt which in the end we mostly finally come down to. And we know that it is contempt which is the most effective to get your job done, because that's when the court can really push hard. The second is the entire concept which we are also frequently now facing. We are facing it in court, we are facing it in everyday life, and is criminal contempt increasingly, which is Section 2B of the Contempt of Courts Act. Civil contempt is Section 2A as Contempt of Courts Act, as we all know. Section 2B is in relation to criminal contempt. Now, criminal contempt, there are two parts of criminal contempt. One is it scandalizes the court. That means you say something which the court really thinks that is shocked. It basically scandalizes the court. The second part is what I consider interfering. It can interfere with the courts, or it can interfere with administration of justice. We've seen this. It's not that we haven't seen this as lawyers who have been in court. We have seen that frequently, in sometimes even, and I'm saying that, you know, most of us don't do it. I think there's none whom I know who does it, but we have seen exceptional people using this as a method to bring pressure onto the court. You know, we all have to be fair in accepting that. So, you know, attempting to interfere in administration of justice, attempting to interfere in the administration of the court can take it up, and it can be considered as criminal contempt. Now, largely, most of this is contempt in the face of the court, and that I'll address as to how the courts have handled it. Because, you know, a lot of time, most of this scandalization, you can do it by writing articles, but there can also be whereby the court itself is, there are people who say something or shout something or do something in the face of the court, in front of the court. How does the court handle that sort of contempt? And I'll address that. I'll address that as I come along. But I think the most important challenge to this contempt power, coming to the topic which we are discussing today, is the increasing issue about freedom of speech. You know, because in the age, and let's all talk today's age, in the age of, let's say, something like Twitter, in the age of something like WhatsApp, in the age of something like Facebook, we are seeing people commenting on courts, people commenting on administration of justice. We are seeing people commenting on legal proceedings. We are seeing people comment on judgments passed by the court. Now, in many ways, you know, we have seen this, that the press, the social media is being used as forums to bring pressure on the court. And by making postings on social media, which, according to me, in a largely would, in any other ordinary sense, would be contempt. We have seen this increasingly being used almost as a tool by people who would ensure that certain some judgments are criticized, some observations are criticized by the court, and more, and in websites, in social media, on the internet, on Twitter, on WhatsApp, we get this very frequently. The intention is, we know, the intention is in a lot of times to bring pressure on the court. If you disagree with the judgment previously, we all grew up in an atmosphere where we said that if you disagree with the judgment of the court, then either you prefer an appeal, or you prefer a review, or whatever is stipulated in the statute book, you prefer that. But increasingly, there seems to be a recourse in social media. There seems to be an attack not only on the judgment, which is an academic criticism of the judgment, which you're entitled to do in terms of the Contents of Courts Act, but there seems to be sometimes attacks on judges personally. And I think this is a huge challenge as to where do you balance? Because let me put it this way, the contours, the freedom of speech on social media, on WhatsApp, on Twitter, on Facebook is immense. People can say whatever they want to. People who would normally not be very quiet, and I can, you know, all of us know that people who are very quiet say horrible things to each other on Facebook and on social media. They write horrible things on Facebook. So, and especially when it comes to a person in authority, especially when it comes to the court, people express themselves very strongly. And, you know, and this, you know, to what extent do we consider freedom of speech and expression as, you know, as absolute? We tend to have two different standards, and we all know this. One standard, which we sort of use in daily life, and the other standard is on social media. We tend to give a large leeway on social media. And there are people from anonymous angles, which wouldn't happen in real life. It's like when I commit contempt, when anybody commits contempt, when anybody says anything, they say it openly. So, you know, if VIKRAMJIT BANERJEE has said something, you can hold VIKRAMJIT BANERJEE liable. But in social media or in a WhatsApp, You don't know who's made that statement. But those statements are made, those statements are covered in the press, those statements are circulated. So it brings a large amount. So where do we draw the line? Where does the court draw that line? Now, so this is the entire question which is becoming more and more apparent. Now, there needs to be some sort of balance. And but on the other hand, also, it's important, and this is extremely important that we consider this, that we also need to definitely also consider that power of contempt cannot be absolute. We all know the entire history in India of truth being a defense to contempt. And these are the two issues. And I'll say freedom of speech and expression on one hand, and I said has to be regulated. On the second is, truth is an important defense to contempt. Should be, because in the beginning, in V.C. Mishra's case, as we all know, the Supreme Court actually said truth is not a defense to contempt. Then the act was amended, the Contempt of Court Act was amended. And now the Supreme Court has sort of come out with a balanced view saying that no. Truth is a defense to contempt unless you can say that the truth was said to camouflage a malafide intent. Now, to camouflage a malafide intent. Now, that's vague enough. That's vague enough. That dances around the entire question whether truth is a defense to contempt. Because let me put it this way: I have huge respect for the judiciary, but truth also has to be said. And what is how good is a justice system which cannot handle the truth? All of us are products of humankind. All of us, being products of human institutions, are imperfect. There is no perfection in any institution. So there should be a way to articulate this contempt, to say truth to power. And if contempt is used to smash down on all these questions, then where is the space for truth? And in today's world, all of us, and I don't want to say it very explicitly, and all of us understand that I'm trying to ensure that I say it correctly without stepping over lines, that there is a clear requirement of balancing the power of contempt with the ability of people to speak truth before the court. Now, what are the challenges which increasingly as a legal profession we face when handling, and where do these challenges actually come from? And I'll say this very extremely generally as I flag mark freedom of speech and expression. Some of it, and I say this as a lawyer, as a person who's experienced the entire thing, is some of it comes from, as lawyers, the profession is not what it used to be. When we all grew up in the profession, we realized that there was a certain maryada, that you are supposed to do these things, you're not supposed to do these things. We increasingly see that getting breached. That's a part of it. Second, we have also, and this needs to be flag marked, and I don't think people speak too much about it, but it is important that it is flag marked, that we have all become too familiar with each other. The bench has become too familiar with the bar, and there is a saying in English law, in English proverb, which says familiarity breeds contempt. As a result, people have started taking the bench too lightly. I think that's another reason. The third is we all face, and these are things which we know every day, that we are also under huge pressure, maybe with commercialization of the profession, maybe an urgency to deliver, maybe the fact that the world has changed in so very many ways that we are willing to push beyond a certain level to get remedy for our clients. But but it also, in some ways, we need to push back. That's what I think. Push back, because we have to protect the institution. We have to protect our own institution, and we have not pushed back enough for our clients. And as a result of this, that has also affected the strategies which we have used before the courts, which we have used while complying with orders, which we have used to understand the spirit of orders, of judgments of court which are passed, of the tactics which we have used in court to address questions of the court. This is our, as lawyers, these have been our shortcomings. But, and now coming to the other side, the response of the bench in handling contempt has also been, not been to the extent that it, we as lawyers would have expected. The first is, which we have all seen, we've all experienced, that the tendency frequently today for the judiciary is to lash out at the smallest infraction. Because, if you look at it from the side of judiciary, it almost seems that they are trying to bring discipline. They're trying to bring everything in order. But they tend to, there is an amount of, almost to the point of, sometimes we may be construed as in threatening. There is, even threatening from the bench that, you have to listen to whatever we have to say. There is an attempt to cajole us. But I would say that the courts have also become a little bit thin-skinned in addressing this question of contempt. One of the examples is, as I said right before when I started my speech, about the entire concept of contempt in the face of the court. Now, we know that when someone does a contemptuous act in the face of the court, there are two ways to handle it. The best way to handle it is that you cite the person for contempt and then you allow some other court to handle and to decide on that issue. And that is what is expected out of the Contempt of Courts Act. That is what is the history of common law. That is how it gives anyone, natural justice, and so that the person gets a fair trial. But the Supreme Court has changed that. All of us who know that case of Leela Daniel knows that there was this entire continuous debate, which actually reflected in the two judges of the Supreme Court, Justice Ganguly and Justice Prasad, differing with each other. In Leela Daniel, the entire question was there was an insulting act done in the Supreme Court in front of it, and the court decides to punish the people who are responsible. Now, Justice Ganguly says that you cite the person for contempt and you send him, to be tried by someone else, while by another court. While Justice Prasad says that if contempt is committed in the face of the court, the court can try it. There is a difference, and it's referred to a third judge, Justice Kabir, agrees with Justice Prasad. So effectively today, if the court thinks that you've done something which is contemptuous in front of it, then you can be cited and tried by the same court, which goes against the basic conceptions of fair play, of a fair hearing. If the person who's accusing you becomes the judge, then there is what remedy does that person have? What remedy does that person have? And these are questions which we need to face up to, and these are questions which we need to consider. These are questions which we need to flag. The second is something, again, I'm sure, which is all very close to us and something which we all know. This is the sort of third big issue which I want to flag. question of, we've seen double standards. And I'm being very careful when I say this. How contempt is treated. Some people get away with it, some people don't. There are some lawyers who do, some lawyers who don't, some clients do, some clients don't. And some people do it on the ground that they have a freedom of speech and expression. Some get away on the ground that there's transparency, and others, other people don't get away with it. And the court comes down very, very hard down upon it. Now the whole question is, this gives rise to a lot of heartburn amongst people. People apparently feel that there are double standards, that people are treated differently. I don't want to name issues. We all know in Supreme Court, it happens. Court comes down hard upon some and doesn't come down hard enough on the other. So in conclusion, to wrap everything up, and I said I'll make a short presentation, not an hour-long presentation. In conclusion, I think there are huge amount of challenges, but I think the most important thing that we have to do, and which we need to concentrate right now, and it's extremely important that we concentrate on it, because that is something which the challenge that we are going to face in the modern age, in the age of social media, as well as this sort of an age where there are increasingly different standards for different people, is that we need to codify what constitutes contempt. We have not codified what constitutes contempt. And if we don't codify this, then we'll continue to be applied, different yardsticks will be applied differently. We can all say that we leave it to the judge to decide, but let us put it this way. People do their actions without knowing that they would come before a certain judge. And I think the more objective we sort of make contempt as an issue, the more it will be easier for us as a legal system to deal with it effectively. In the age, as I said, in the age of freedom of speech, increasing freedom of speech, that is extremely crucial. It is extremely crucial because we are also in a legal system which is now expanding to all corners of India, and we are facing increasing challenges. With that, I would like to conclude whatever I had to say. Thank you very much for giving me this opportunity to say it. I can't hear you.
I said, thank you, Mr. Banerjee. The way you presented the things in a subtle manner, and the sublime touch of your issuing all issues which are on a wider canvas. The painting put across ultimately has come out fantastically well. And fortuitously, Mr. Justice Pramod Kohli, who had been the Chief Justice of...
Such a pleasure, I know, Justice.
No, he needs no introduction. He's an institution again.
Yes.
We all respect. He had been one of the most respected and loved judge out there. Yes. He also had been at one point of time doing the roster of contempt.
Yes.
Once I just saw that Justice Kohli is one of the persons who's hearing him, I asked him that it would be quite unfair that if once we find that Justice Kohli is in the platform and we don't hear him.
Yes, such a pleasure.
We would like to have insights, because Mr. Banerjee has expressed what he has done as a lawyer. We want to have the insights what you have, because you have been an Advocate General of J&K, you have been the Chief Justice, you have been a judge.
Yes. So
we have seen both sides of the coin. Mr. Banerjee and myself or other lawyers are just like Shole's coin, which has only one side. Yes. Let's have the insights from you, Justice Kohli. Over to you, Justice Kohli.
Yes.
Very good afternoon, Mr. Banerjee, and all those persons, my friends, members of the legal fraternity who are on the platform. It was my privilege to hear Mr. Banerjee. This is the second occasion that I am hearing Mr. Banerjee There was the earlier occasion when both of us were together in a seminar, and I had the privilege to hear him, a wonderful lawyer, a gentleman at par excellence. And I must say that he has explained the subject in a very, very concise and fine manner, not going into much details, but what he wanted to convey and what was the requirement of the subject, he has done that. Friends, so far law of contempt is concerned, I have traveled 5 courts, and my experience as a lawyer in civil practice, as a law officer, and as a judge has been quite different in different situations. But my experience says that most of the violations are committed by the bureaucrats of the government level. And Mr. Banerjee may not be able to say so openly, but that is my experience both as a judge and as a lawyer. I have seen the orders finalized by the Supreme Court, and the bureaucrats write notes that because of our rule position, because of our practice, it is not possible to implement the judgment. How do you deal with such a situation? The contempt law is the only weapon, only instrument where you can force to implement the judgments. The object of contempt is not to punish somebody, not to take a revenge, not to act or react angrily. I remember an incident which may explain. I was a small kid, maybe 12 years or 13 years. I went to village. My mama had 2 guns in his drawing room. Once I asked him, Mama ji, these guns, do you fire from these guns or they are just junk? His wonderful reply was, look here my child, when these guns are hanging in my drawing room, no thief will come. They are scared that I have guns. So that serves my purpose. Law of contempt is like that. It should be used as guns hanging on the wall, but not meant to be fired to every person and everyone. Of course, there may be circumstances where it may be needed for upholding the majesty of law, not for individual ego of a judge, not for the act committed by a person. You see, there may be circumstances. We have seen some litigants are really frustrated, and because of many reasons, maybe attitude of the court, maybe the circumstances prevailing against around him, and that is not a situation where you should fire, even if the offense committed by such person or such litigant may be beyond proportion. Therefore, law of contempt should be utilized as an instrument to enforce the judgments and degrees of the court. I remember I was in Jharkhand, and labor award was passed in 1987. It attained finality within 5 years. The SLP Hemming will dismissed by the Supreme Court. The judgment was not implemented in favor of the laborers. A big factory whose management was foreign, one contempt petition was filed. The honorable judge gave them another 3 months, which was originally given, and this contempt was filed after 2 years. It was again not implemented. A second contempt petition was filed after a year. It was again not implemented, and no directions were issued. A third contempt petition was filed, which came to be listed before me. I was really shocked. In contempt jurisdiction, which is something rare, besides issuing the notice to the contemners, I ordered for the attachment of the property. That factory, running factory, if the judgment award is not implemented within 1 week, you will be surprised. 10 lawyers, including from Delhi, Calcutta, and Patna, came and appeared to defend that man. And ultimately, within half an hour, they decided to implement the judgment. The judgment was implemented. I directed that the persons who are the beneficiaries should be given the money in the court itself. I was shocked. That was a bad day of my life as a judge. Then the persons who are the beneficiaries, it was in some cases, it was second generation, in some cases, it was third generation. Can you imagine? Therefore, here the law of contempt comes handy to the courts for implementing, for doing the real justice. Therefore, my view is that law of contempt should be there, but it should be utilized in the manner that it serves the justice and fairness while deciding while implementing the judgments of the court. Another instance I can give you, I was in Srinagar, the Dal Lake, very famous, everybody knows. There was a direction that no construction shall be constructed within 2 kilometers of the fringe of the within the periphery of the lake. A committee was constituted of the district judge, a registrar high court, and a retired district judge and a district magistrate. The committee went there and found a big building, huge construction was being raised in a forest area. Then they approached and find out it was a building being constructed by the DG police of the state. They made a report, and with great respect to sometimes to the honorable judges also, nobody had the courage to issue notice to the DG police. He was a very powerful man during militancy. That case came to be allotted to me, and during those days, that only one case was being taken up as a PI. I took the file, I read the entire file, and next morning, I asked the lawyer, government lawyer, can you produce the DG police before the court? He said, no, how can I? You not issue any order. I issued contempt. That house was attached, and then the report was summoned. It was a forest land. Security money, more than 75 lakhs, was spent for the construction of a house, though government house, no permission, no plan, no approval. And ultimately, that DG had to seek transfer from the J&K state and went to center on deputation because he was a powerful man. So the contempt law should not be frequently used to such an extent, but where it is required, it must be used to uphold the majesty of law. Thank you very much.
So thank you. And it also shows that you were just caught unaware. We saw you on the platform and we called you. And you,
thank you so
spoke off the cuff, and we are so happy. And this also shows the volume that why the state chose you to become the Advocate General, why you became a judge, and why you became judge. So what has been your experience in the different high courts while handling with the Court of Contempt Act? How does it vary? Does it vary from state to state? We would just like to be got enlightened from that fact.
Yes, definitely it varies from state to state. My experience that in J&K during militancy particularly, the bureaucrats used to feel that issuing contempt notice even, that by contempt you will not initiate it. They used to take it as an offense and even go to the extent of accusing the judges in open. But that was not so in Punjab and Haryana. The bureaucracy was more compliant. In Jharkhand also, the bureaucracy was more compliant. In Sikkim, of course, bureaucracy compliant. But in Delhi, in CAT, the things were again different. The top bureaucrats used to take it an offense that the court has issued notice to such a bureaucrat, even for implementation of judgments which are finalized by the Supreme Court of India. But for a common man, most of the people used to obey the judgments, and it is also observed that even if an officer wants to implement it, perhaps the person sitting at the helm of affairs, maybe bureaucrat, maybe somebody else, they prevent its implementation, taking it as an offense and as an ego, question of ego, that how can, particularly as a member of tribunal, the feeling is that perhaps the tribunal is subordinate to the government, and issuing contempt notice used to be taken in a different way.
Thank you. Mr. Banerjee,
Yes, sir.
question has been posed.
Yes.
Something on social media with the covered under the feel and expression. Honorable Supreme Court in Shriya's case, how we are protected by commenting or put views on social media? Can you guide us?
See, this is what I was talking about. I don't recollect that there has been the court has come down orally a number of times, and social media being used to sort of, according to it, pressurize the court. But I don't recollect any judgment whereby the court has actually laid down any principle on how it deals with contempt vis-a-vis social media. I think that's an area which, as I said, it requires to be seriously considered. The court has been, I remember a few days back, I won't name the Supreme Court judge, I was before the Supreme Court judge, and a very tricky, sensitive matter was being argued, and the court observed that we are seeing all these things on social media. We know that it's to influence us on social media, which would amount to interference of justice, interference with the court in any other circumstances, under the Contempt of Court Act. But the court, I don't think, has laid down. It requires to lay down. I don't think it has laid down something, but it requires, and it's very seriously requires to lay down some sort of guidelines on how this is going to be effective. There are no guidelines, actually speaking. People get away with a lot.
Shruti Agarwal asks, what is the thin line between the contemptuous conduct and not showing politeness and reverence towards the bench?
That's what I'm saying, and that's what I said, that we need to codify it. That's what I said, that it requires increasingly we need to codify it. Irrespective, there may be problems at our end as lawyers, and Justice Kohli is there in front. As I said, I'm putting up my hands as lawyers. Maybe our behavior is not perfect, but we think, and I'm of the view that we need to codify it. 1, 2, 3, 4. This is what constitutes contempt, and this is what doesn't constitute contempt. I think it's very important. We don't have that. It depends on case to case. It depends on judge to judge. That's very tricky. I'm not comfortable with that. I know it, in the end, you can always say, but to that extent, you need a little bit of discretion. But I think something which can constitute violation, clear violations, especially which has maybe even have criminal repercussions, I think it requires for some standards to be very, very clearly laid down.
Thank you. Ayush Anand has posted a question. Do you think because of the absence of proper channelized systems to complaint against the erring judicial officers through the concerned administrative higher court and improper redressal of the issue concerning erring advocates by the BCI, the instances of contempt are increasing?
I think this is in many ways we can blame everyone. Whether this is a question which means that whether it's a system's fault, that contempt. I think it's partially, of course, the system's fault, but I don't think that in any way, if there is a better resolution, if lawyers are strictly held to a standard, things would be solved. We need to lay down, and I'm very clear on this, we need to lay down very specifically what constitutes contempt, what doesn't constitute contempt, because we are now a very diverse country. The reason I'm saying this is it goes back to the second point about lawyers that I made. Previously, in a different generation, lawyers came from a certain background, judges came from a certain background, and they knew amongst each other what was the line to be crossed and what lines were not to be crossed. Now, the world has changed, India has changed, and it's changed for the better. It's very important that we realize that, lawyers from various different backgrounds come. It's good that they have. And as a result, it's extremely important that, people know in a transparent manner what constitutes contempt and what doesn't constitute contempt. So that if in any time in future a lawyer violates that, you can put it up before the lawyer. It could also be helpful to the Bar Council of India, saying that you put it up before the lawyer, saying this is what the rules are, you've committed contempt, or you've committed, whatever, malpractice or whatever as a result. So it's extremely important to lay it down. Otherwise, it's always what in Hindi is called tu tu main. I will say something, somebody else will, the judge will say it constitutes contempt. I will say I was just maybe a little impolite. I was not being deferential enough to the judge, and so therefore I was cited.
Justice Kohli, you can answer this question because you have been a judge. During the pendency of a contempt proceedings, the respondents made a statement that the case of the petitioner is under process and she will get the benefit in terms of the judgment. Thereafter, the contempt petitions were disposed of on the statement, but the needful has not been done. Is a fresh contempt tenable or a revival is best recourse?
You see, these are only technicalities. Whether you file a fresh contempt or ask for a revival, both are permissible according to me. I don't feel that one should enter into technicalities this way or that way. In my opinion, both the methods are can be appropriately utilized. But some courts,
thank you,
on technical grounds say, but my feeling is as a judge, which I have been doing also, that whether it's a revival or whether it's a fresh contempt, both should be maintained.
So we have always appeared before you. We always found that the distinguishing factor between in your court was you never went for the technicalities. You ultimately believed not only in justice but substantial justice. The rigmaroles of the technicalities were never the stopping ways in any manner. So the next question is, Mr. Banerjee and Justice Kohli, either of you can take. Yeah. In view of the wild and open reach of social media, and especially the lack of formal education to the masses, do you still believe that in case something wrong is posted, he or she could be hauled up for contempt?
You're asking me?
Well, any of you can answer.
I think Justice Kohli, and then I'll put my take onto it. But Justice Kohli obviously has precedence, so let Justice.
See, Vikas and Mr. Banerjee and all those on the platform, I bona fidely believe that there are certain things which should be ignored by courts. The court should not enter into some kind of struggles with the masses where it can be beyond the control. The very object of the contempt law is that things should be brought within the control of the court. But if it tends to go beyond the control, you see, then it becomes very difficult for the court to handle it. Social media, of course, firstly, only the educated class or urbanized people mostly look into social media. It may be, definitely there are aberrations, and which aberrations one cannot understand and even tend to, you see, malign the judges, the institutions. But let it be left to the governments of the state or central government to handle these things, and courts should not enter into this arena, because it will be, the court will have no agency, and the implementation would be ultimately at the hands of the government, and you don't know what could be the method of implementation of the orders of the court. Therefore, my humble submission is, we should not react. Courts should be large-hearted, and such kind of things should not be taken up by the courts. Courts may only ask the government to handle it, but not, they should not take upon their own shoulders, because it may go beyond controls. Then the dignity of law, not only the dignity of law, the privilege of the judges will also be, you see, marginalized. That's my.
As for me, I broadly agree with what Justice Kohli has said, and I don't think the court should get into every post on social media. In fact, the entire objective of contempt is to ensure that the majesty of the courts are retained. And I think to react to everything on social media, I think takes away from that majesty. But on the other hand, the court needs to consider as to whether certain social media postings or certain social media actions are done to influence the court at the time of hearing, whether that constitutes an interference in the course of justice. As is used, I'm not saying it's not used. I think Justice Kohli is also aware of the fact that it's used.
Yes.
Whether it requires for the court to come down hard upon that. because this is very frequently in the in olden times. There used to be one article in some newspaper which used to be, but in social media it's almost like an avalanche. And there are judgments of the court which says that this can amount to interference of justice. So it requires to be seen. It requires a mind to be applied to that, and that's what I said. The court needs to come out with some sort of guideline as to how it handles social media.
Of course, I agree with you that there may be guidelines, but again, the question is, under the guidelines, should the court take upon itself the burden of dealing with the person, or should it be a direction to the government or to make some law, make it an offense, punishable, such kind of a suggestion? I don't want that the court should enter into this arena itself and take the burden. Then it becomes the court will be burdened only with such kind of litigation, which may not be good, which may not be, I think, good for the institution itself. What to talk of the judges?
Yes.
And then more motives are attributed.
Yeah, that's true. That's true as well.
And even from the senior lawyers, that's unfortunate.
Exactly.
There has to be mutual respect. That's why the court should not itself take upon its shoulders the responsibility of dealing with such kind of aberrations and elements.
Yes, sir.
Thank you, sir. Harpreet asks, if the period of limitation is over, what is the remedy after the period has expired for limitation?
I would say that you can't have a limitation period if you've committed contempt. It's a criminal act in some ways. So you can't say that I committed 20 years back if I said something. But of course, the court should feel it relevant. So that's what I'm saying. There's a lot of part of the Contempt of Court Acts, Contempt of Courts Act is a little unclear at the edges, and it requires some sort of clarification. But these are things which are technical issues, and at the end of the day, it depends upon the court. It depends upon the court as to whether it still thinks that would amount to a valid contempt, whether there is an interference with the course of justice. This is contempt power. These are contempt powers. Yes, sir.
Because may I answer this question?
Yes, sir.
Yes, sir. Yes, sir.
The question was to you, and once you are working in tandem, we couldn't have a better session than this.
Yes.
There are two ways of looking at the issue. One is the limitation prescribed under the Contempt of Courts Act is meant for whom? Is it meant for the litigant to invoke the contempt jurisdiction, or it is meant limitation applies to the court also, where the court also itself moves contempt notice? So my view is that where the litigant invokes the contempt jurisdiction, perhaps the limitation may be effective. But where the court is of the opinion and which justifies the statement of Mr. Banerjee that technicality should not be, where the court is of the opinion that it's a case where the contempt jurisdiction should be exercised, it can not only be under Contempt of Courts Act, it can be under the Constitution also.
Yes.
We permits that. The second opinion, the second is, even without invoking the contempt jurisdiction, still the judgment can be implemented by way of an execution as an order of the court. Any order of the court is in the nature of an injunction. And my view as a student of law, as a humble student of civil law particularly,
yes,
it can be executed as a decree of the court, as an order of the court. And sometimes there is a misconception that contempt of law is most powerful instrument for implementation of the judgment. I say even the execution jurisdiction,
yes,
much larger. You can send a person to civil prison under Order 21, Rule 32, because it's an injunction. You can attach the property of the person. So there are many ways of enforcing the order, even other than by invoking the contempt, which I have been doing in CAT.
Yes.
I found that execution orders passed in execution, treating it as an execution, have been implemented more than the contempt jurisdiction.
Justice
Yes.
Kohli had always believed when he was there that justice must not only be done, but it must be seen to be done. And he always found that the majesty of the court is paramount. And taking, with the leave of both of you would probably agree that Article 215 and 129,
Yes.
there are judgments to the effect that Section 20 of the Limitation Act will not act as an embargo, because it has certain judgments are to the effect that the Act cannot be in breach of the limitation provided under Article 215, since Constitution of India will ultimately be made. Ankush Bansal asks, can a judge initiate contempt proceedings if an advocate makes a bona fide mistake in a courtroom and after that apologizes for such mistake?
You see, I have dealt with such a matter. In CAT, a very senior lawyer had secured his interim order, stay of the promotion in the department from a single member of the bench during vacations, and the other side, including those who were in the line of promotion and the government, they came forward saying that the department is suffering because of the promotion of the entire lot. So I suggested to the lawyer that how many petitioners are there? Perhaps there were 12 petitioners. I asked how many vacancies. There were 44 vacancies. I said, all right, till we hear the matter, we can modify the order saying that 12 vacancies may be kept here, and if they succeed, they will get all the benefits, and we'll vacate the stay order to that extent. The lawyer did not agree. He wanted the court to decide it. I said, all right, if possible, we'll hear it tomorrow, and if not, the order itself says then we'll hear the application for application. Next day, he tried to stretch it to such an extent that it is not heard. Then another date was given, and ultimately, when the order was being dictated for modification, he said, you are doing injustice. You are a partial judge. I tried to persuade him, look here, you are a very senior lawyer. This is not the way you should deal with the court, and I respect you as a lawyer, but not the manner you are. But he did not bother and raised the finger at me that, yes, I am saying, you want to punish me for contempt, you may do it. I again said, look here, you are in anger. I don't want to do with a senior lawyer, you are an officer of the court. But he insisted. Then I initiated contempt against him and asked him to file a reply within 2 days, served him. Then I retired and went to the chamber. The whole executive body came and wanted that he should apologize. In chamber, I said nothing to him. Whatever has happened in the open court, it has to happen in the open court only. Then next day, they passed a resolution boycotting my court. I came, my registrar told me at 7:30 in the evening that they have the executive has passed a resolution. I said, okay, it's all right. That is their duty, and I will come and sit at time. Next morning, I sat at time, and about 100 lawyers came with the wearing robes and said that some lawyers are preventing them from appearing and they should be tackled with. I said nothing doing. I asked my registrar to talk to the DCP and ensure that no lawyer is prevented from entering the court. That's all. Then I think the lawyer realized that it can't work. Then he tendered apology. After tendering apology, they said, you pass an order. I said, no, I'll pass order. You have tendered, that was your job. I have to do my job. You have tendered apology, I will deal with it. I asked the order, detailed order, that's a reported judgment. What are the duties of the lawyer? What are the duties of the courts, judges? And I warned him and said that if in future he behaved like this, the court will, the contempt will revive. Sometimes you have to do things like this to prevent. And then I came to know that that lawyer was using was bullying every member of the tribunal. So sometimes at some event, you have to call a spade and stop this. And this is the position I think that Honorable Supreme Court should also take up the issue, and at least for future generation, don't allow the future generation to spoil themselves. There has to be stopped somewhere, such things. Though the court should have large heart to receive the criticism of the judgments. And sometimes, I don't know, but it is very necessary to uphold the dignity of law, the justice of the institution. That's very important.
After the final order of the High Court, maintenance is fixed, but husband does not pay the maintenance, not compliance with it. Then we should file an execution in the trial court, or can it be filed in the contempt court?
See, the final court is not basically the court of execution court. It should always be in the trial court, the court of first instance, the executing court. Therefore, it is always prudent. Rather, the legal position is that the trial court or the court of first instance to pass the order. Even if where the judge, supposing the trial court rejects and the order is set by the higher appellate court, even then the execution will go to the court of first instance.
Nitika
I
Sharma
think-
says,
Yeah.
Mr.
I
Banerjee.
think, yeah, my experience is, all of us know this, that eventually if you go to the High Court will ask you to go back to the executing court to get it executed, get his whatever salary attached. All that action will happen. So why prefer contempt? I don't think that, if somebody came to me, I said, you may have a remedy, but it's never going to be, High Court is never going to entertain you. It's going to be actually the first court where you are present. That's where your forum is. So I agree with Justice Kohli on this.
Since Mr. Banerjee, you had given inputs on the WhatsApp, etc., a question has been posed: relevancy of the precedent where the admin of the digital communication, example WhatsApp, are being held liable for contemptuous view, even though one member whom he has inducted as a person posts some message which is offensive.
The great question is to what extent is the admin applicable? I know what the rules are. There is, there are a lot of rules which are there are a lot of rules which are being framed. I've seen those rules, some of them, which makes admins liable because it casts the obligation on the admins to ensure that WhatsApp groups are not misused. But as to how much they would be liable, they may be liable under those rules which are framed. But as to whether they will be liable under Contempt of Courts Act, I'm not very clear, and I don't think that's they would be liable under the Contempt Act per se. But yes, they may be liable under those rules which are framed by the government to ensure that people cannot post all sorts of things.
So Nitika wants to pose a question. Nitika, you can pose the question to both of them.
Yes, sir. Thank you.
If you find it good, you can come on the video also.
Yeah.
No, sir, audio is fine for now for me. Thank you so much, sir, for the opportunity. And I thank the host as well for conducting such brilliant webinars for us. So my question is, if an order has been passed in the High Court and it is divided into two parts. So both of the parts are not implemented by the executive. So one part, so we go into contempt, and one part is taken up by the court, and the court says that this part is to be implemented, and the court is, and the contempt court is silent about the second part. So in that situation, what are we supposed to do?
If you asked me for my strategy, I would say you bring it to the notice of the court, saying that these are what we consider, this constitutes contempt as well. But the fact of the matter is, again, that's the entire question. There's a lot of discretion with the court, and the court may consider, and we've seen this a large number of times, we've taken benefit of it at times, and we've suffered it also at times, that the court thinks there are certain things which are contemptuous of it, and certain things which doesn't consider contemptuous of it. But that's the discretion of the court on this. And the court may, and a lot of times we've seen saying that, no, they have tried to comply with the order. So substantive compliance, so all these are questions which are used, which leaves a lot of discretion to the court. It's fine. We all, as lawyers, use this strategy at various points of time, but as a person who studies law, I would rather have this some sort of enumerated, some sort of codified.
So, sir, sorry to interrupt you, sir. So, sir, we cannot file any review, or we cannot go to court again to suggest the court that they have left behind one part of the order, which is very important.
Whether you want to go for a review, whether you can go for a modification, these are questions which you can explore. These are legal strategies which, as a lawyer, you would be best able. Without looking at the papers, you would be best equipped to take that call on. I would say, if I would, I would also say that this is to suggest to the court, but the discretion of what constitutes contempt or not is up to the court. It's completely up to the court. So if the court, even after you mention it in your review, or you mention it in a modification, says that, no, I don't think that constitutes contempt, and it's happened. It's not that it doesn't happen. I've experienced it. Then that's the end of the matter.
All right. Thank you so much, sir. Thank you so much for the input.
Harpreet Kaman also wants to ask the question. Nidika,
Yes,
you can mute yourself.
All right, sir.
Yes, sir.
Harpreet.
Yes, sir. I have a question. If the Honorable Supreme Court passed an order in the SLP in 2017 and direction was given to the government to implement the orders to deposit the land acquisition, enhanced compensation in the bank accounts of the landowners, and after that, till today, the government has not deposited, even if we have filed the execution before the trial court. But trial court also, court of first instance is sitting on the files and not implementing the orders of the Honorable Supreme Court. So we have left no remedy. We cannot file after the limitation period contempt of the court. So what is the remedy for us? After passing of 3 years of the Supreme Court judgment, even then executing court is sitting on the orders.
Can I ask this question first before I answer the question? Is it the government of India?
Punjab government, state of Punjab, sir.
So I think you can, if you think that the order is not complied with, of course you have the remedy of contempt. You can bring it before the court, saying that your orders are not being complied with.
So
the general answer.
Limitation period has been passed. Limitation period 1 year is passed. 2017 the SLP was decided.
Limitation period as to what? Limitation period as
contempt. We want to file the contempt before the court because the government is not implementing the orders of the Honorable Supreme Court in SLP.
As to if there is an order of Supreme Court and it hasn't been complied with, I'm sure an application can be made. Even now, I think
we have, sir, we have made the execution before the trial court to implement the orders, but trial court is also sitting on the orders.
Yeah, that's a separate issue. Since you've exercised your jurisdiction before the trial court, whether you can then exercise jurisdiction before the trial court. And also
my question is, we want to file the contempt petition before the court, before the higher court.
We can ask Kohli to pitch in. Hello.
I'm sorry?
Hello?
Yes.
Hello?
Justice Kohli also to pitch in because
yes, Justice Kohli can. But my view is you can't prefer both remedies together. That's my view. Yes, but of course, Justice Kohli.
Objection would come into being.
I fully endorse Mr. Banerjee's view. You can't have simultaneously two remedies available under law. But one thing I feel as a lawyer, no, I am not saying as a former judge, as a lawyer, one can invoke jurisdiction of the High Court under 227, seeking the appropriate direction for the executive court to in the interest of justice. That may be one of the which can.
And Justice Kohli, thank you very much. I am the same Harpreet. You got me transferred to Kharad when you were inspecting judge at Rupert. And thank you very much. For the first time, I am talking to you directly.
I really don't remember.
Yes, sir. I remember your good efforts towards me.
Okay. I can just also express my views. In such a given like situation, Mr. Banerjee would also express his views. Doctrine of election would also come into being. Either you have to choose the execution and either you have to choose the contempt. You can't take both the strides together.
That's my point. That's my point, actually. That's
Again, sir, after the passing of 39 years of the acquired land, the poor landowners are not getting their relief. See, sir, after passing of 40 years, after the finality of the SLP, what to do with the executives, sir? What to do with the executives? They do not want. They have some technicalities in executions we face. Sometimes this is not, that is a very lengthy procedure in the executions itself. So after finality, sir, where poor person can go? Justice is only in the books, sir. They are the poor landowners. They don't have anything to eat. There is a corona time. They called me up. Okay, madam, what to do with it? How to cope up with the situation?
Saying, once they have the persons giving input to you, you should also make them aware vigilanta bus, non-dormanty bus. And Mr. Banerjee, we had a wonderful session as we had discussed. I will also
Thank you
ask
very
Mr.
much.
We are not ending the session because we had asked, since you yourself are an inspirational story for young lawyers, young students, etc. What is your take? How to make a path in the career? How do you think one should go for the drafting? How one should make a mark within the society as a lawyer? That people say, what Mr. Banerjee could do, why should be? What are your takes on that? What is your chapter?
My take is anybody can make it. I've always said this, and I exactly say the reverse. And I always tell my juniors, if I can make it, anybody can make it. I'm not a person who sort of believes that I'm an exceptional lawyer, or whenever you're given work, you do it. You work hard at it, and you try to make the best presentation of your case as possible in the court. You try to be as honest to the brief as well as to the court. These are three things which I follow: that you work very hard at your brief, you try to be honest to your clients, to yourself, and to the court. And I think that's enough. And I the rest, I think, is taqdeer. There are whole loads of people who will tell you that, I worked very hard and I worked through the nights. Of course, you have to do that. That's expected out of you because that's your responsibility. I don't think there is any escaping. If anyone, and I look at it this way: if I was a doctor and my father was a doctor, he would get a patient. He would work very hard to ensure that the patient gets better. So that's a given. Beyond that, there are certain things you have to do. One is be fair to yourself, be fair to the client, and be honest to the court. And the biggest thing I would say, and this is something which I'm sure Justice Kohli would bear me out on this, that your credibility, and this is what my senior told me, that your credibility to the court is the most crucial. So, lots of times as young lawyers, and even me, under tremendous pressure, under a lot of pressure to say something or do something, cut some corners, but you in the end have to resist it. If you resist it, if you have credibility with the court, then the court hears you, gives you a hearing. And as a young lawyer, as a lawyer coming up, that's the only thing which you can ask for, that you should be given a hearing before the court. And then court itself makes out as to, how much you are aware of the brief, how much you are not aware of the brief. That's the other part of it. Honesty, I would say, is important. That's what I follow. And responsibility. These are the two things. I don't think there is any other great magic potion which makes anyone better or anyone worse. And the third is luck, I guess.
I am reminded of Mr. Jinnah when he said, what are the factors of your success? He said, first is luck, then second is luck, and third is luck. But still, what you told, according to me, the gist comes in that the difference between a good lawyer and the successful lawyer or a lawyer would be one is hardly working and one is working hard. Justice Kohli, what is your take, since you have been the president of the bar, advocate general, the judge, and the chief justice, then thereafter, and the cat? Above all, you have been a wonderful human being. What is your take? What one should do for the purposes of drafting? What one should do to become a good lawyer, and how one should draft it, etc.
Because you can keep a complete session on this, and I would love to speak on this subject
Sir,
for the complete session. But right now,
sir, we will do that. Abhi a trailer dekh lete hain, picture puri dekh lenge.
Right now, I can say that it is not necessary that only the persons belonging to a legal family having legal background can be successful. It is the wish of the God, and as you have said, Jinnah's statement that luck is everywhere. There is no dispute about that. Your destiny, your luck, but this is such a profession which may be so of every profession, but in law particularly, profession of law, there is no substitute for the hard work. I can say no substitute for the hard work. I have seen very competent, very intelligent lawyers. Their grasp is so beautiful, so wonderful. They just photogenic memory. They just read a page in half a minute and remember everything. But still they may not be successful. And to the contrary, person who is working, I have no hesitation in admitting that I was just an average student throughout my life. But once I joined the profession, what we have learned from our seniors, working 8 in the morning till 12 in the evening. So that has, you see, shaped us as a lawyer. There's no substitute for hard work in this profession. The rest, wish of the God, and many things follow. I am very happy that Mr. Banerjee has said one thing very important, which is crucial for a good lawyer, and that is the credibility in a court. If you lose credibility, you lose half of the discretion of the court. If you have credibility, you win, you acquire half of the discretion of the judge. Therefore, credibility is so important, so crucial to this profession, and that comes with your actions, with your hard work, with your efforts, with your dealing with the court, with your presentation, with your approach, with your attitude towards the court, towards the litigant. Credibility is not only before the court, credibility is also before the litigant. If you lose the credibility of a litigant, you always fire them, throw their files. Perhaps litigant, despite you may be best lawyer, may not come to you. So credibility is a comprehensive term, which may be for the court, for the litigant, for your colleagues.
Yes.
If you have no credibility amongst your colleagues, and if you want a copy of a petition, your colleagues may refuse to, if you have no credibility. If you have credibility, the registrar, the office, everybody will deal with happily. That credibility is crucial in your life as a professional particular.
Gaurav Malhotra wants to ask a question. We will come back to your success journeys directly. I would be unmuting Gaurav. So no further questions will be taken thereafter. I stand corrected. You can ask the question directly.
And can you hear me?
Yeah, I can hear you.
Yeah.
Yes.
Happy to see such cordial relations between the bar and bench. My question to you is, how can one decide in what court will the contempt lie? is it based on the jurisdiction or the same court, or it can go to, because under section 10 and 11, it can go to High Court as well. So how do you decide the jurisdiction for that?
I'm sorry, can you repeat the questions once more? I'm sorry.
How do you decide the jurisdiction in which court the contempt will lie? For example, it has to be on the basis of the jurisdiction of the district court, or it can go to section 10 or 11 in the High Court, or so how do you decide the criteria to in which court, or the court from which the order has been passed, contempt will lie in the same court?
Under the Contempt of Courts Act, as you rightly said, you know that under the Contempt of Courts Act, the higher courts can effectively have contempt powers over of the lower courts of other tribunals.
Suppose it's a tribunal, or suppose it's a body like an MCD, and then you have to I had sought an injunction from MCD, and
Yes.
now those things are being breached, and I had filed a contempt in the district court.
Yes.
But there's a jurisdictional issue in this.
I would say, I don't know the intricacies of the matter, and would not be fair for me to comment without knowing the intricacies of the matter. But I would say I have always preferred the High Court, maybe because my practice has always been in the High Court, because you can get things done maybe a little more faster.
I see.
In the High Court, but that's my experience of it. I don't know the intricacies of the matter, and it wouldn't be very fair for me to comment without looking at, what's the exact jurisdiction.
The basic case is I had sought an injunction from the MCD.
If you just examine section 2, 10, and 12 of the Contempt of Court Act, it will clarify large number of doubts. The commentary of section 2, 10,
I think Gaurav has
along with Article 2.
Gaurav has seen that, but I think he has more intricate questions, which I think it requires a little bit more examination of the papers and to what strategy he would like to frame.
Okay. Another just one short question: who all can be the witnesses in a contempt court? Can you compel the judge of the previous trial court to be a witness of that proceedings in the contempt proceeding?
Tough question. See, if it's a, let me put it this way. Let's take it straight. If it's a civil contempt, then the court itself considers what is contemptuous and what is not. I don't, it can cite you for contempt. But to my experience, you can suggest that, the civil judge is going to be my witness, etc., etc. But to my experience, I don't know whether a higher court will want the civil judge to be present or to be cross-examined in any manner.
I see.
I have not seen that. That's my experience of it. I don't know whether yours may be different, and I'm sure that I've never seen such an incident. It's a lot of times we raised that issue that maybe the civil judge, there was no violation of it, and the civil judge would be the best. And civil judge, I know for a fact, is sometimes even made parties to a contempt petition, etc., etc. But I have not seen the judges ever calling the civil judge for cross-examination.
I see.
Many ways, or for even filing an affidavit. I have not seen that. That's my experience of it.
Thanks a lot. One last question just to conclude. In case of an interim order, the contempt would lie in the same court? If there's an contempt of an interim order, as of that point, you don't have the option of going into execution.
Yeah, I would say I can speak for the High Court. I think subject to ever. If the court has passed an interim order, let's say an order of mandamus asking you to construct something or do something, and that's disregarded, that the only solution is either issue another mandamus or to enforce it through contempt, so which would lie before the same court.
That's great. Thanks a lot.
Justice Kohli, your insights over the last question which has been posed by Gaurav.
You see, without going into the intricacies, how the question of jurisdiction is sought to be resolved, I can simply say that normally the court which pass the order should initiate the contempt also. But the High Court has always the jurisdiction under the contempt of courts, under the Constitution, not only to deal with the contempt of its own, but of the contempt of subordinate court.
Yeah.
That is clear mandate under the Constitution and even under the Contempt of Courts Act.
Contempt of court.
So High Court can always, but again the question is if the discretion of the court. But normally the safest course is to approach the court which has passed the order. And even interim orders are to be implemented, whether by way of contempt, by way of any other method. Even Order 39 itself provides for enforcement of the orders passed by the interim order passed by the court.
Yeah.
Therefore, I don't think any much debate is needed. But
Yeah.
just to simply have a look at the provisions, and you will find that the remedies are available.
Yeah.
Sometimes I would like to speak on the civil procedure code that has been a subject very close to my chest when I was a lawyer, and I will at least remind myself of those intricacies of law which we used to apply as a civil lawyer. And
Thank you, sir. In fact, the technicalities had never been the facet to stop you. You always took cue from Justice Krishna Iyengar's judgment of wherein he said that the technicalities cannot be done for so admission.
I can never think that I'm anywhere, even thousands miles close to Krishna.
So I'm not connecting to you. I said the spirit what Dolly Chandra etc. judgment said. Those judgments that the technicalities cannot be used as a mistress to spoil the ends of justice were always followed by you.
That's right.
It's all. Our session ends till 1:30. It was a wonderful session.
Thank
we have
you.
not put any of the questions which were where comments and suggestions had been called for. We just asked the questions which are relevant for the purposes of the platform for what has been created. Comments for this we can always read the newspapers, etc. We have Mr. Prashant Chaudhary again from Northeast. So we said Mr. Kohli, though is from Jammu, but he served as a Chief Justice in Sikkim. VIKRAMJIT Banerjee from West Bengal and this thing. He had been the Advocate General of Nagaland.
Yes.
And Mr. Prashant Chaudhary, he was introduced in one of the sessions when Justice Bhalla came. So we thought there could no better person than Mr. Prashant Chaudhary, though who has studied in the North in Snar, to give a vote of thanks. And thank you everybody who has participated. Prashant Chaudhary will do this. In the evening, we are having a session by the ex-DGP of Chandigarh, IPS, the life skills for the lawyers. That is the soft skills and other skills, how to improve your writing skills, etc. I would ask everyone to join that, whosoever wishes. Those who want to connect with us, they can connect on WhatsApp, Instagram, and the Facebook. Over to Mr. Prashant Chaudhary. And Mr. Banerjee and Mr. Kohli, as Mr. Kohli has promised that he will come again, we will take him. And we also look forward for more fruitful journeys with Mr. VIKRAMJIT Banerjee.
Thank you.
Mr. Banerjee.
Thank you. Thank you,
And
Vikas.
over to Mr. And sir, you came. It is just like a night watchman is immediately called upon, and he comes and plays a double century. The same way you came without anything, and you have performed. You have also become the star of the present session. Over to Mr. Prashant Chaudhary.
It's such a pleasure hearing Justice Kohli and Mr. Banerjee. One realizes that as you all are rising higher and higher, you've reached the level of the pinnacle towards your successes, and you all are equally humble in your approach to all of us. And we would be grateful if we hear more of you all on this forum by Mr. Chatra. In fact, seeing you all on this forum, one is reminded of the Shakespearean Veni, Vedi, Vici. I came, I saw, I conquered, and that's exactly what you all have done to us. We would really thank you for your insights, and we would ask Mr. Chatra to bring you back on some other session where we may address you all directly. We may have so many things further to discuss and enrich our lives from your experiences. So we thank you very much from the bottom of our hearts. Mr. Chatra, we thank you for putting us together on this forum, and we hope to see you all in the Northeast where we can take a look at Mr. Banerjee's insights into Nagaland, which I've had a little different experience from Mr. Banerjee, because now we have, thanks to Mr. Adarsh Goyal, who came from your High Court in Punjab and Haryana, he's implemented the CPC and CRPC. So we have similar courts
in Dimapur.
In all the districts now. We have public prosecutors even in Tuensang, Mon, and other places, which are right next to the Burmese border.
Yeah.
So we would definitely see that the Punjab and Haryana High Court and the lawyers from Delhi who served in the Northeast have contributed far more to us than we who are sitting here have done over here. Thank you very much.
Mr. Chaudhary, without even asking the permission of Mr. Banerjee and Mr. Kohli, I can say they are not like flowing water that you cannot touch the same water twice. Neither they are the same time which cannot come back again.
They
will definitely come.
They are just
like perfume bottles. Whenever they will come, they will spread their aroma, and we will all enjoy it. Thank you, everyone.
Thank you.
Thank you, Vikas.
Thank you.